Good day, good morning, greetings, greetings, greetings. I am Natasha Robinson, and I am the creator and curator of Legalese. Please, if you are here joining me live, please come in the comments so that I can say good morning to you. Good morning. I am Oya Gente. I hope I'm saying that right. Oh, it's my sister, Andrea. Thank you. Elay, thank you so much. That name kind of threw me, but now I know it's you. Thank you. If you are here, please click like and share on your platforms. As you come into the room, please let me know that you are present so that I can greet you. I am Natasha Robinson. I am the creator and curator of Legalese Please. And as promised, I told you that I was going to come on live after just being live on Court TV from 9 a.m. to 11 a.m. Central Standard Time. That's 10 a.m. to noon on Eastern Standard Time. So, one of the things that I'm learning about live TV, I knew this already, but it's different when I appear. Oh, they should just thank me by name. Great, great, great. Is that when live TV is coming on, of course, you can't script or you can't predict what is going to happen. That's the first thing. The second thing is that if there is a court case that is live, that is happening live, then the deference and the focus is on the case itself so that you are able to hear what is happening in the case as opposed to the commentary about the case, because that's what Court TV does. It allows us inside access to see what is being testified to, the objections that are being made, and the information that is being shared. So if you are on live, please come on and say hello. If you are watching later, please put your name in the comments so that I know you are here. But there are a couple of things, of course, because you're on live TV, there are things that you want to talk about, but you're not able to talk about because the time in which you are on is so brief and to the point. And so I wanted to come on and in true Legalese Please fashion, wanted to make some explanations so that you are able to understand what is going on. I also want to say good morning to all of you on Facebook, live later, as well as those who are watching via LinkedIn, and to our family on YouTube. Thank you so much. If you have not already, you can go to Legalese Please, which is the official website of the business. You can subscribe to YouTube channel by going to the link that is on your screen so that you are able to watch this episode as well as prior episodes for Legalese Please. And then if you are not connected with me or to me on Legalese Please, these are the different social media locations. You can, of course, follow me on Facebook at Legalese Please LLC. I am also on Instagram, YouTube, and Twitter, all of which are on under the name, rather, of Legalese Please. So glad to see you here. So let's get into it because my time is brief with you. I wanted to get in where I fit in, and I wanted to discuss with you some issues that have shown themselves in this case that we have been watching. So if you have been on Court TV, or if you have been reading or watching information regarding Wisconsin versus Darrell Brooks, the allegations is that Mr. Brooks, on November 21st, I believe it was, of last year, he is accused of speeding through this Christmas parade and killing 6 people and injuring 70 something more people. And so he is being charged with intentional homicide, meaning that he is accused of doing this act on purpose. And then he is also charged with different counts in terms of the attempted homicide, meaning these persons were injured, but they were not killed. And so this case is followed nationally because this is something that hit the news. Another reason why it is followed nationally is because the defendant, the accused, Darrell Brooks, is representing himself. He is representing himself. And so when you represent yourself, that is called pro se representation. Okay, pro se representation, which means you are representing yourself. Now, the Constitution of the United States guarantees that you have, through the Sixth Amendment, a right to counsel. Okay, a right to counsel. And so you also, meaning you, the defendant, if you choose, you are able to ask the court if you can represent yourself. Now, what is involved with representing oneself? I've never represented myself, but I have represented hundreds upon hundreds upon hundreds of people. And so what representation usually requires is some type of recognition by the state bar of the state in which you practice that you have met and satisfied all of the requirements to practice law. Those requirements include graduation from college or university, and then a number of recommended, I will say required years in an accredited law school. And then if you want to practice law, you have to, the terminology is sit for a bar exam. Sit meaning you are taking a bar exam, which for Illinois, which is where I reside, comes in three parts. The first is the ethics portion, which is you are asking, or rather you are answering a bunch of hypothetical questions about what you would do if you represented a particular person. That's the first part. Then the second and third part are usually closer together. The first day is when you are taking the actual bar exam, which can be 200, what is called a multi-state, 200 multi-choice exams, multiple choice questions, where you have to read through a fact pattern, and then based upon your study, you have to articulate what is the best answer. Then the second part, or the second day of that, is there are 30 essay questions that are provided to you, and then you have to choose, I think, 15 to 17 of them, and then answer those questions. Once you do that, all of that, and you pass all of that, and then you are sworn in by the Supreme Court of the state. In this case, I was sworn in by Justice of the Illinois Supreme Court. Once you go through all of that, then you are able to legally represent someone in court. That does not mean that you are proficient. So just because this is legal does not mean it is proficient, because you have to learn. You have to learn and implement different objections. You have to learn how to do foundations and evidence. You have to know what the law is. You have to get to know your client. You have to get to know what is there for defense is a story of innocence. For the prosecution, you have to talk to a person who has been harmed or injured, and you have to articulate for them and represent them to the best of your ability. And then you got to get to know the judge. You got to get to know the courtroom staff. And this is just on the criminal side. This is a side that I have been on for now, I think it's 23 years. So we're not even talking about civil law, which is where a lot of cases have to go through what are called interrogatories, where there's a lot of written information, written questions that you get from both sides to see how you prepare for the case in court, if it gets to that. So with criminal law, all of that is what you have to learn. And that is just for lawyers. And I haven't even gone into all of the aspects that lawyers have to learn and go through. The organization of evidence, the creating of direct examination and cross-examination. What questions are you going to ask? What is your legal theory for why your client should be found not guilty? Is it because there is not enough evidence of proof, or is it because that there is what's called an affirmative defense, which is where you are saying on behalf of your client, I did what I am charged with. However, either I have a legal justification for why I did, such as self-defense, or the law excuses me from accountability because of insert whatever the because of. Usually excusable affirmative defenses are something like insanity, which gets us to the point of what we are discussing today. Understand that everything that I just laid out is for those who are licensed and practicing and active attorneys. So when you have a layperson who says that they want to represent themselves, even if they are a lawyer, there are a lot of intricacies in a criminal case, let alone a murder case, let alone a case where a defendant is charged with 6 homicides that he is alleged to have committed with his actions. So it is a very nuanced case. And then it is in front of a jury. Okay. There are different policies and protocols for what to do when you are in front of a jury, when you are doing a jury trial. It's a lot. Okay. So for this particular defendant to face the charges of killing 6 people and injuring a lot of others, and then taking on the added challenges of representing himself, which means he has to be well versed in the law. He has to be well versed in evidentiary procedures. He has to be well versed in what the prosecution and their witnesses are going to argue, as well as what he may argue. All right. It's a lot. So this case is on Court TV, and quite frankly, it has been very painstaking to watch because, again, when you have someone who is not a legal professional acting in that role, then what regular legal professionals may do or not do is the opposite of what is actually going to happen. So the 2 things that I want to talk about with you today are competency and insanity. Competency and insanity. These are things that I did not get to discuss on Court TV because the balance of the time was given to the watching of the case as opposed to listening to the analysis of the case. So competency and insanity, these are terms that we usually hear a lot in criminal cases. And I want to explain to you what they mean in layman's terms. So when you're talking about the competency of a person, what you are speaking to is, what is your mindset now in court? What is your mindset now in court? So in most, if not all of the United States courts, there is a presumption of competency, meaning you are presumed, you are guessed to understand. This is the judge. This is the prosecution. This is the defense. This is what a criminal charge is. This is what the prosecution has to prove. These are what are called exhibits. This is the questioning that I am to engage in for direct examination. This is the way of cross-examination I am to engage in a criminal case. This is how I can help my attorney by providing information as to the who, what, when, where, why of the case. All of these are factors that lead to the understanding that your mindset now, your comprehension of the criminal court now, is one in which you understand everything. Now, you may not be able to rise to the level of being an attorney, but at the very least, you understand that you are being charged with something and there is an institution or a body of people who are accusing you of something. And whatever that something is, it is saying that you have broken the law and need to be held accountable. All right. So competency talks about what is your mindset at the time you are in court. All right. So in order to represent yourself in terms of pro se representation, it has to be presumed, unless you try to overcome that presumption and says you're incompetent. When you are representing yourself pro se, when you are representing yourself, you are saying that I am understanding everything that is going on in court and I am able to assist in my own defense. which is why the court has to make another finding of competency of the defendant in order for the pro se representation to exist. So in this case with Darrell Brooks, the judge had to establish that there was a finding of competency, meaning before she could say, sir, you can represent yourself, she has to say he is able to represent himself. Now, why is this important? This is important because according to the timeline, when he was represented by attorneys, he, through his attorneys, placed into evidence his plea of not guilty by reason of mental defect or disease. That is called insanity. So he made a case, or he was making a plea of, I am not held or to be held accountable for these alleged crimes because I am insane, or I am saying that there is a reason, a mental defect or disease that prevents me from understanding why I could not align my behaviors or my actions or my words to the state's legal expectation. That is competency. I'm sorry, that is insanity. Okay, that's the definition of insanity. Insanity is what was your mindset at the time of the alleged crime? What was your mindset at the time of the alleged crime? So Mr. Brooks, in his initial representation by his attorneys, was saying that he was insane by reason of a mental defect or disease. He was saying, in essence, what his plea was saying is that I did these crimes. However, I'm not to be held legally responsible for these crimes. There is a legal reason, a legal excuse why I am not to be held accountable. And that legal excuse is insanity. All right. So he is representing himself, pro se representation. He initially, through his attorneys, was saying he was pleading not guilty by reason of insanity, meaning I am not guilty of committing these crimes because the law recognizes my mental defect or disease, and that provides a legal excuse. All right. However, not too long before this trial started, he withdrew that plea. So he went from the plea of not guilty by reason of insanity to just not guilty. And then his attorneys filed a motion to withdraw their representation because if you've been watching, I know there were probably some very intense times between him and his attorneys. So because his attorneys and him were not on solid ground in terms of the understanding of how they were to proceed in trial, in essence, they withdrew. Mr. Brooks asked to represent himself. And after a series of questions, the judge agreed. All right. So I want you to understand that when someone pleads guilty, not guilty by reason of insanity, it is not the issue of quote unquote craziness, meaning that they are talking to themselves or they are doing something, their appearance is unkept. It's not like that. It's not like the insanity what we see in movies or what we read about or anything like that. Insanity is about, was there a mental disease or defect at the time of the alleged crime? And as a result of that disease or defect, it prevented the defendant from aligning their actions, their behaviors, their words to the expectations of the law in that particular state. All right. So if he had kept this plea of not guilty, then that means that if the judge allowed him to, he could have presented evidence that talks about any hospitalizations he's had in the past, any diagnoses he's had. He can offer up those medical records subject to them being entered into evidence correctly and legally. He can also call in doctors, treatment providers, pharmacists, anyone that has direct and relevant knowledge that he lives with a mental disease or defect that prevented him from understanding what he was doing at the time of the alleged crime. Okay, so when we're talking about insanity, also understand that for insanity cases, it is less than 1% of all criminal court cases in the United States. Only 1% of those cases have an issue of insanity. And just because you raise the issue of insanity does not automatically mean that you will be found insane. So of that 1%, only 24 to 26% of that 1% has successful outcomes where insanity has been argued and has been won. So what does that mean? That means in everyday terms, everybody's not pleading insanity. Okay? Just because you live with a mental illness or defect in this country, that is not an automatic shield to prosecution, and that is not an automatic barrier to being found guilty. It's quite the contrary. So these are all of the things that are coming into play for the issue of Wisconsin versus Brooks. I will say, as I was not able to say on Court TV earlier, due to the time constraints, that this is a very painstaking trial. It's an interesting one. And it's one in which the jury is going to have to pay specific attention to the evidence and the testimony that is presented, because Mr. Brooks is arguing with the judge, arguing with the prosecution. Any answer that a witness gives, he is making an objection. And not only is he making an objection, he's telling the prosecution, what are the grounds for your objection? So it's moving painstakingly slow, because Mr. Brooks, while he is representing himself and he has the ability to ask questions, he is asking relevant and irrelevant questions, mostly irrelevant. But because he is not a legal professional, a defense attorney, or a prosecutor, he may not know or may not care that some of the things he is asking is really has nothing to do with the case. Also, add to the fact that the prosecution witnesses are not only being questioned about what they saw and what they witnessed, but they are being questioned by the person they are saying is doing this thing or has done this thing to them or to someone that they love or someone that they know. And so that is an added layer of difficulty and challenge as well. So it is estimated that the prosecution will close their case and rest either later today or tomorrow. And then Mr. Brooks, who is the accused, he has the right to present his case in chief. His case in chief is nothing more than his side. Is he going to give an opening statement? Is he going to testify on his own behalf? Because if he does testify, then that means that the prosecution has the right to cross-examine him. It's also been reported that he has issued about almost a dozen subpoenas to different people. And so the issue will become, does he execute those subpoenas? Meaning, does he call those witnesses? What is his strategy? One of the subpoenas has him calling the state of Wisconsin, which is such a general subpoena. It's not really even a subpoena that one can acknowledge, because who are you calling in the state of Wisconsin? Are you calling the entire state? And if you are, what are you doing? So to me, those are just signs that Mr. Brooks, although he is legally representing himself, he is not representing himself in the same or similar way as an attorney would, because he does not have that training. You can tell that he does have, some level of intelligence, and he is trying to get to a particular goal. What that goal is, I have no idea what it is. And this is why it is so long. I think it's day 10 of the prosecution's case. I think it's day 10, which means that this has gone longer than what usually happens in these type of homicide and murder cases. So I did want to just raise that because of the time on TV and the fact that the focus was on the case itself as opposed to the commentary about the case. I wasn't able to raise these issues to no one's fault. It's just that's just how things happen when you are on national live TV. All right. So I thank you all so much for your support. Again, you can go to anywhere that Legalese Please is on social media. You can go to Facebook, you can go to Instagram, YouTube, and Twitter. You can also subscribe to our YouTube channel so you can watch not just this episode live or later. You can watch other episodes in which I address a myriad of legal topics. You can also go to legaleseplease.com and you can peruse through that website. And there may be some services that you can avail yourself of as well. So I just wanted to show you those things. I thank you so much for being here. And also be on the lookout because Legalese Please is going to be offering a webinar. That's right. I'm going to be offering a webinar, and that webinar is going to benefit you. So once I get that information, be on the lookout for that on all of the social media sites that I have discussed. I thank you for your time and your support, and I want you to have a fabulous day and the rest of your week. Thank you for attending. Bye-bye.